Good morning, everyone. Welcome to Division 1 of the Court of Appeals. We have two arguments scheduled for 9 o'clock or between 9 and 10 this morning. The first one is StressCon versus Travelers Insurance. I see the lawyers are set up and ready to go for that one. And the next one is People v. Cano. Are the lawyers here for that case? Okay, we'll hear argument second in that. Let me just briefly review our procedures. I imagine that you're familiar with them, but as you know, we have 15 minutes for each side for oral arguments. We have our traditional lighting system that's green when you start and amber when you have 5 minutes left and red when your time is up. We also have the digital timer, so especially if you're representing the appellant, you can determine how much time you want to reserve for rebuttal argument. You should know that we've all read the briefs and we've had an opportunity to look at the record, so you may wish to focus your argument on the legal issues rather than the facts, but of course how you present your argument is up to you. You should be aware that there's a toggle switch on the podium that you could raise or lower to suit your convenience. You should also know that we're live streaming the oral arguments, so if there's any private or confidential information, you may wish to be careful about how you refer to that. And finally, I would ask everybody, if you have a cell phone with you, make sure it's turned off so it doesn't interrupt us inadvertently during the oral arguments. So with that having been said, we're ready to go.
My name is Evan Stevenson, attorney registration number 37183. I represent Travelers, the appellant in the StressCon case. I intend to reserve 3 minutes of rebuttal time.
Very well.
May it please the court? In 2016, the Colorado Supreme Court issued an important opinion in this case. The Supreme Court corrected far-reaching legal errors that tainted and polluted the trial against Travelers. As a result, both the Colorado Supreme Court and this court issued appellate mandates that expressly reversed all judgments against Travelers. Those reversals had the effect, by operation of law, of setting aside the tainted jury verdict against Travelers. Both.
Excuse me, Mr. Stevenson, if I know you stated that as well in your briefs, and if that's so, why wouldn't the Supreme Court have put in its remand order that the jury's verdict was vacated and the case was remanded for a new trial?
It didn't need to say that, Your Honor, initially, because a reversal by operation of law has that effect automatically under Colorado Supreme Court authority. But second, the court should not have immediately ordered a new trial because it was still possible under the remand instruction for Travelers to win a directed verdict on remand with no trial.
Well, but under your interpretation, the Supreme Court's language that was issued in response to the petition for rehearing would be a nullity, because there would be no reason for this court to have to look for any reasons to say that the direct motion for directed verdict was correctly granted. How do you, in other words, if it was just a straight reversal and everything that happened at the trial court was null and void, there would have been no reason for that language in the mandate?
I wouldn't say that everything in the trial court was null and void. I would say that the judgments were set aside, they were reversed, that the jury verdict was set aside, but things before that point were not set aside. I think that's what the case law provides.
Well, but if the division here were to conclude that there were reasons that the directed verdict could have been denied, then doesn't that indicate that not everything is wiped out by the Supreme Court's decision?
No, I agree that not everything was wiped out, but the judgments were expressly reversed, and the full reversal of a judgment automatically, under Colorado Supreme Court authority, sets aside the verdict that produced it.
But that would make the mandate make no sense.
I think what the mandate says is that the judgment's reversed, the jury verdict is reversed, and the case returns to the point at which Travelers made its directed verdict motion at the close of StressCon's case. So at that point in time, there was no judgment, there was no verdict. The proceedings up to that point are not wiped out, and the courts re-examine the case as of that point in time. The way I would put it is the court rewinds the case to halftime. And if Travelers prevails on its motion for a directed verdict, the case ends the same it would if we were having a trial the first time and Travelers were to win a directed verdict motion.
But if the converse is true,
If the converse is true, then as with any other trial, you would proceed to verdict with a new trial.
why? How do we read that into the mandate?
Right, the mandate contains that because well-established law says that when when a judgment is reversed, the judgment no longer exists in the eyes of the law, and the jury verdict is set aside automatically. And the case by the Colorado Supreme Court that we cite in our brief, the Prudhoe Valley case, cited on page 33, provides that an appellate court will not reverse unless there has been prejudicial legal error. Other cases that we've cited, the Cavallari case, the Garrity case, the Farmer's Elevator case, all provide that when there is a reversal of a judgment in full, as here, and the facts are conflicting, and there has been correction on appeal, the default position is a new trial. The Supreme Court corrected 4 far-reaching errors that would have made a huge difference to the trial.
Mr. Stevenson, you just said, in referring to those cases, that if a judgment is reversed in full, but didn't the Supreme Court, by amending its opinion in response to the petition for rehearing, do something other than reverse the trial court's decision and the jury verdict in full?
No. The Supreme Court reversed in both versions of its opinion. In the first version, it reversed and directed a verdict in favor of Travelers. StressCon then filed a petition for rehearing that explicitly asked the court not to reverse the judgment. StressCon acknowledged in that petition for rehearing that the original opinion did reverse and asked the Supreme Court to take that language out. The Supreme Court did not do that. The Supreme Court reversed again and gave a different remand instruction than StressCon proposed. And StressCon also asked for a remand just to this court, not to the trial court, so that this court could review the entire record and the appeal could continue and they could find an alternative basis to affirm. None of those things were done in the second opinion that the Supreme Court issued. The Supreme Court still reversed the judgment in full and remanded the case to reconsider Travelers' directed verdict motion. Under Colorado Supreme Court authority, if that motion is denied, the result is trial. And here, there are 4 far-reaching legal errors that would require a new trial. The first legal error that the Supreme Court corrected was that Travelers was required in the first trial to prove that it was not prejudiced. That error invited a flood of evidence that should never have come in. The second error that the Supreme Court identified was that Travelers was allowed to be attacked for not protecting the business interests of StressCon. The Supreme Court held that that was error. That was one of StressCon's main trial themes. Taking that theme alone out of the trial very likely could have resulted in a different result. The Supreme Court held that the no voluntary payment provision is a fundamental coverage term, which is something that none of the courts below had held and would have changed the expert testimony, would have changed the jury instructions. These are all things that would have been dramatically different and that were changed. This is why the Supreme Court didn't vacate in part or not reverse and just simply send the case back here for examination for an alternative ground for affirmance. The Supreme Court reversed. And then this court reversed as well in its own mandate. The fourth error is that the Supreme Court held that there must be exposure to the insured above the policy limit in order for the insured to go and make an unauthorized settlement, as the insured did in this case. Those 4 mistakes, all corrected by the Colorado Supreme Court, if implemented in the first trial, would have changed everything from top to bottom.
Mr. Stevenson?
Yes.
Even if those 4 errors would have changed the complexion of a trial if they hadn't occurred, how do any of them affect the issue that we're addressing today, which is whether or not Travelers had denied coverage to StressCon?
Yeah, so it does affect that in a number of ways. First, the attack on Travelers for denial was based on the idea that Travelers should have been protecting StressCon's business interests. The argument against Travelers was that by not doing anything, by exercising its contractual express discretion to do what it did or to not do what StressCon thought it should be doing, that it therefore was denying coverage. Now, we disagree with that, but that's one way in which a specific error corrected by the Supreme Court would affect the very theory that StressCon now wants to assert. And if StressCon were right that it's irrelevant, that the Supreme Court's decision were irrelevant, the Supreme Court wouldn't have reversed in full. The Supreme Court would have vacated in part or given a different instruction. There's no way around that. The Supreme Court reversed in full in response to StressCon's request that the judgment remain in place.
But aren't we limited by the fact that it only granted cert on one of the issues?
No. And that's well established as well. The fact that the Supreme Court doesn't grant cert on several other issues says nothing. It is not an adjudication of those issues. It's not an affirmance of anything as to those issues. There's no case law to support that. StressCon cites no law of that nature, and none exists. And it's common for the Supreme Court to...
Well, based on your reading, what was the point of the remand at all?
The purpose of the remand was to return... First of all, the purpose of the remand was to see if Travelers was entitled... I'll tell you this. The purpose of the remand was to see whether the Supreme Court got it right the first time when it directed a verdict for Travelers, and if not, to have a new trial. That was the purpose of the remand. So what happened was the Supreme Court initially thought that Travelers should win as a matter of law. StressCon protested, filed a petition for rehearing, and said, no, we're not dead yet. We can still survive. So the first part of that remand instruction is to see whether the Supreme Court got it right the first time, that Travelers should be the one prevailing as a matter of law. And if not, you're left with an ordinary reversal, as in every other case. What happened in the trial court's error was in flipping the purpose of that remand instruction. A remand instruction that was intended to give Travelers an opportunity to win as a matter of law was transformed into something like the opposite. StressCon was able to win as a matter of law simply by not losing a motion for directed verdict. There is no precedent for that. StressCon cites no examples in any state or in the federal system where a party merely survived a motion for directed verdict and then was allowed to obtain judgment as a matter of law on judgments that had already been reversed. That was one of the trial court's core errors, among several others.
Well, Mr. Stevenson, I'm surprised to hear you say that. I mean, isn't it possible for there to be alternative bases to rule for or against a party in a particular case?
Yes. Here, there were none, and we know that because the Supreme Court not only reversed in full, if there were alternative grounds that the Supreme Court thought could prevent reversal, it wouldn't have said what it did. And then second, we know that because in paragraph 22 of the Supreme Court's opinion, the Supreme Court said that the Court of Appeals and the trial court made the same error for, quote, precisely the same reason.
Excuse me, Mr. Stevenson, you said you wanted to reserve 3 minutes for rebuttal. You have about 2 minutes and 40 seconds.
Yes, Your Honor. Thank you very much.
Morning, and may it please the court. Sean Connolly, 33600 for the plaintiff appellee StressCon. 1 decade ago, Travelers unreasonably denied StressCon's claim for insurance coverage. 8 years ago, a Denver jury so found. 5 years ago, this court affirmed that jury verdict in its entirety. And then 2 years ago, the Supreme Court reversed on one aspect of one defense, expressly remanding to consider whether different grounds defeated that defense. Judge Talman, you said this was not a reversal in full. Plainly it was not. They reversed on one ground, not 4 errors. They accepted cert, Judge Terry, on one ground, voluntary payment defense. They reversed on one aspect of that one ground. And after originally in paragraph 22, saying the jury verdict is vacated, they deleted that language. And they said the judgment of this court is reversed, and the case is remanded to consider any alternative ground defeating the voluntary payment defense. That's exactly what Judge Lemon did on remand. She considered whether a different ground, the fact that Travelers had previously denied the claim, defeated its right to invoke the voluntary payment defense to prevent StressCon from protecting its own interests.
Mr. Connolly, after the Supreme Court decided the case and it was remanded to the district court, did StressCon ask Judge Lemon to hold a new trial?
No, of course not. And neither, Your Honor, did anything in the Supreme Court mandate or this court's mandate suggest that a new trial was necessary. This was one defense, and the issue was, as Travelers had raised it and said, don't let this case go to the jury, that we have a voluntary payment clause in our contract that prevented StressCon from settling and protecting its own interests. That was their defense, and they argued at halftime. They argued originally in summary judgment to Judge Hoffman, then at halftime, and then at the close of all the evidence, said we've got a voluntary payment defense. This case should not go to a jury. StressCon raised 2 arguments in response to that. And actually, the first one is the one that was never addressed until Judge Lemon did on remand. And the first argument was they cannot invoke a voluntary payment clause to prevent us from protecting our own interests when they previously denied coverage. And under the law, when an insurer denies coverage, it only is fair and makes sense, and it's well settled everywhere in the country, that if an insurer denies coverage, an insured then can protect its own interests. And that's what StressCon did, Your Honor.
I have a question in that regard. What does denied coverage mean in this context? Must there be a judgment, a verdict, something that is clear and definite, or what does it take?
There doesn't have to be a judgment. There has to be a denial in saying that in no event are we going to cover this claim. And that was communicated. And this is sufficiency of the evidence. And this is something that the original panel, Judge Bernard's lengthy opinion, as not uncommon, but very lengthy, thorough opinion of Judge Bernard, unanimous on this point, paragraph 67 to 69 said Travelers did deny the claim and went through the evidence and in length. And it does not have to be before a judgment. The denial happened when Travelers officials told StressCon that you don't have coverage for this claim against Mortensen or by Mortensen against you because it's contract-based. We only covered tort claims. And they also said, and we're also an excess insurer. 2 grounds, they said that this claim is not within the scope of the insurance.
That was in a reservation of rights letter, though.
Well, not only. They said that in reservation of rights, but that's not what the evidence, proved the denial on. If that's all it were, then that would not be a denial. They communicated to StressCon, we have no interest in ever participating in resolving this claim. Unlike 2 personal injury claims, Your Honor, 2 people in this tragic accident back in 2007, one was killed, one was injured. Travelers did step up and try to adjust those claims because they thought they were tort claims, and they thought the policy was limited to tort. They communicated very clearly, and the testimony at trial from their own officer, a guy named Robert Nevins, said we were never going to cover because we thought it only covers tort claims, and we thought we're only an excess insurer. And they were wrong as a matter of law on that thing, and it was unreasonable. And that was the basis of them telling StressCon, communicating to StressCon, that this is not going to be covered.
I think you can tell from my questioning of your learned colleague that I'm concerned about the scope of the mandate and what it is that we are even permitted to do at this point. Can you please address that?
Yes, Your Honor, thank you. I think the mandate is very narrow. And it says, in what it says and what it doesn't say. And what it says is, and this from the Supreme Court, that the Supreme Court then passed down to this court, and this court passed down to what became Judge Lemon, who had to step in for Judge Hoffman, the original trial judge. But the mandate is there another preserved ground that defeats the voluntary payment defense? And that preserved ground, which was preserved, Judge Lemon found not just sufficiently, but doggedly and thoroughly, her words, and Stresscon's first argument is, you cannot invoke the voluntary payment defense against us when you've previously denied coverage and denied our claim.
Did that exceed the scope of the mandate?
Did that
Judge Lemon's ruling on that?
No, Judge Lemon faithfully executed the mandate, and she said, I've got a very narrow task before me. I'm very complicated by a voluminous record, but my narrow task is twofold. Was this argument preserved, that you previously denied the claim? And Travelers originally argued that this wasn't preserved, and she had to spend time going through, and she said it was preserved doggedly and thoroughly. I think they've abandoned that claim, thankfully. Then the second thing is, did they previously deny coverage? And was there evidence, more importantly, not did they deny coverage, was there evidence that a jury could conclude that they denied coverage? Because we're talking about a directed verdict standard. So the question is, framed by the Supreme Court, is there another ground for denying Travelers' directed verdict motion based on a voluntary payment defense? That's all we're talking about. And interestingly, in the 12 minutes of my colleague's argument, I don't think he ever even addressed the one issue that really is alive, because I don't think they have any good arguments about it. But plainly, this argument was preserved by Stresscon, and plainly there was evidence that would support a jury finding, in the light most favorable to Stresscon, that this previous denial vitiated their right to invoke the voluntary payment defense.
In your view, are we permitted to look at other coverage defenses?
No, absolutely not. First of all, I think this is all law of the case, and there's a dispute about the effect of what I call Stresscon 1. I think they try to pretend it didn't exist, and that was Judge Bernard's opinion for unanimous court, except for a separate concurrence on one narrow issue that's no longer relevant. But that rejected a slew of claims, including claims that this division, or not this division, that a prior division held had not been properly preserved. So this case should be, as most cases are, narrowed as you go through the stages of a case. And we're not back to 2010, except to the point of one thing, that the mandate required the district judge, Judge Lemon, as it turned out, to re-examine should that directed verdict motion of Travelers have been granted and prevented the case from ever going to the jury. And when she found properly so that there was a ground, the prior denial, that defeated that defense, then everything else is intact.
So why, given the scope of the mandate, why were attorney fees an open issue?
Well, because this court, the division, originally had said that we're entitled, that Judge Hoffman got it wrong back in 2010, when Judge Hoffman said that Stresscon is not entitled to, quote, fees on fees. And the original order of this court was to say that affirm the judgment, the jury verdict stands, and sent back for additional fees, both in terms of what Stresscon should have gotten in the district court way back in 2010, fees on fees litigation, and also for appellate fees. Now, obviously, once the verdict is in limbo, and that's really what it was, I think the verdict's in limbo then. I think after the Supreme Court decision, we don't know whether the verdict is going to stand or not, because the Supreme Court said one of the grounds that the district court relied on, and that the ground that the division affirmed on, the notice prejudice rule, is not a ground that vitiates the voluntary payment defense. That's the only holding that the Supreme Court made. It's the only question they agreed to review. That's the only holding they issued. And they said that one of the grounds, the notice prejudice rule, does not apply, over a very powerful dissent by a very distinguished justice of that court. But anyway, 4-3, they said that the notice prejudice rule doesn't apply. So that's out of the case. Then they said, but in response to rehearing, is there another ground, a different ground, that also defeats or separately defeats the voluntary payment defense? And that's the only thing that was left open. And then when it's sent back to Judge Lemon, it's one of two options, I think. She could have said that no, Stresscon, this prior denial never happened, or it's not an adequate ground for defeating voluntary payment. In that event, Travelers is an outright winner, and then we could appeal and come back up. But Travelers is the outright winner at that time. Or she could have said, as she probably did, that this prior denial happened and it defeats their right to rely on voluntary payment. And in that event, their halftime motion and their summary judgment motion and their full-time motion are denied, and the case was properly submitted to a jury. At that point, you don't vitiate the jury verdict. At that point, the only issue was, should this case have ever gone to a jury? She said, yes, Judge Hoffman properly allowed it to go to a jury in 2010. And then the question is, then the jury did its job. And so, and it's not a case all of a sudden that the mandate nowhere said that there has to be a new trial.
So
Nowhere
why
said,
does it permit new attorney fees to be awarded?
because at the end of the day, StressCon's the prevailing party. And StressCon had to run the gauntlet, and that's a phrase used in StressCon 1, and it's used in other cases of this court. And when you are the prevailing party in a case for bad faith denial of insurance benefits, you're entitled to the fees you spent that you would not have spent or incurred but for the denial.
And that's based on your interpretation of the statute, correct?
Not just mine, that's based on Judge Fox, so there was going to be, in the Nybert versus Geico case, said, and based on every fee-shifting case, says that you don't deplete a fee award or a benefit award by making somebody run a gauntlet and not get fees. This is and the Supreme Court has made clear since then in Casper and other cases that this is remedial in the sense that it avoids an award from being depleted. And
Mr. Connolly, how does what you just said square with the cases that hold that if a prevailing party is only partially successful, it's only entitled to attorney's fees on the part of the case on which it prevailed?
that really wasn't argued here. This case, we were fully successful. At the end of the day, we are the sole prevailing party. Now, I think if they're trying to say that you look at each battle along the way, and if you lost at one level of a court and one step phase of the case so you don't get fees for that case, that's just not the law, Your Honor. That would deplete, contrary to the policies, that would deplete the award that we're entitled to. This is a but-for test. But for their bad faith in 2008 to 2010, these fees would never have been incurred. These are fees that StressCon incurred solely because, and should never have had to file this lawsuit. And that's really the idea of fees being actual damages, but for their bad faith denial in 08, 09, and 010, and leading to that jury verdict, these fees would never have been incurred. And you don't look at, at each step of the way, did we win in the Court of Appeals? Did we win at the Supreme Court? Did we win at each level? We won at the end of the day. If this court affirms, as it should, Judge Lemon's ruling that we were properly avoided a directed verdict and the jury verdict stands, then at the end of the day, we have prevailed. We are fully prevailed, Your Honor. We've not lost anything. We lost different battles. That always happens, though. You could lose a motion, lose a discovery fight, lose one step of the proceeding. But the question is, at the end of the day, what happens? And that's really what this court has held in different cases, saying just because you won at a trial level, at the end of the day at appeal, if you lose, you don't get any fees. Just as here, if you lose a one step of the appeal, and we lost on one narrow issue, and that was in the Supreme Court, on one part of one defense. Now, the Supreme Court very well could have said, we're going to consider this alternative ground, all right? They could have said, you lose on the notice prejudice, but you win on the prior denial. And had they done that, we would have gotten all the fees for the Supreme Court, not because, we won on one ground, lost on another. At the end of the day, we would have been the whole victor. Likewise, this court could have, back when it was remanded, the court could have, without remanding it back down the chain, could have said, the original division or some of the division of this court could have said, okay, we're now going to consider this alternative ground. And then when we consider this alternative ground, we agree that there was a prior denial and that vitiates the voluntary payment defense. Had the court done that, it would then have properly awarded fees for the whole proceeding. The procedural context shouldn't matter. At the end of the day, we were the sole prevailing party on the entirety of the claim. And we incurred hundreds of thousands of dollars of fees in 8 years of litigation that we should never have incurred, but for the bad faith denial of this claim back in 08, 09, 010. And those 8 years of litigation costs, if they're denied even in part, that is diminishing the benefit that the legislature intended by saying you're entitled to twice the covered benefit and to actual fees and costs resulting from the bad faith. That's the Supreme Court's holding in Goodson in 2004. That's a but-for cause. What was the cause of these actual damages was the bad faith denial. And then you don't look at did you win in this discovery fight or there? So we asked this court to affirm, and to affirm the award of fees by Judge Bronfman as well, and also to remand for additional fees for this appeal.
Thank you, Mr. Connolly. Mr. Stevenson, you have 2 minutes and 37 seconds.
Thank you, Your Honor. So I'd like to address the prior denial argument with my remaining time. So the prior denial argument also, that Stresscon made in the trial court also led to error. The trial court should not have ruled that a prior denial was sufficient to enter a judgment under the double damages statutes in Colorado. That was an erroneous finding, an erroneous ruling for two legal reasons. First, the jury finding they're relying on merely says that Stresscon denied a claim before the settlement. It never satisfies the essential element of reasonableness. Those statutes, in order to enter a judgment against travelers, require a finding of unreasonableness as to the prior denial, which is what he's staking the rest of his case on. There was no such jury finding. That is another reason why, even if you agree with Stresscon's construction of the mandate, there was error below. There was no finding that the prior denial was unreasonable, and that is an essential element of this statute. In fact, Stresscon's already been made whole for the contractual damages it claimed. After phase one of the trial, one of the subcontractors insurers paid Stresscon all the contractual benefits it was owed. The sole subject of this action is statutory double damages and fees, a surplus. And for that extra amount, there must be a finding of unreasonableness as to his alternative ground, prior denial, which there never was. On that ground alone, there was error that requires reversal. And second, in order to establish even that he's not bound by the no voluntary payment defense, as he calls it, or the no voluntary payment argument, he would have to show an anticipatory material breach here. And I believe it's undisputed that there was no finding of that. In fact, Stresscon presented to Judge Hoffman an anticipatory breach instruction, and it was rejected. That's actually a battle that Travelers won in the trial court. It won the battle over anticipatory material breach, which I think we've shown in our briefs is the correct legal standard for setting aside the no voluntary payment provision. You cannot set aside a no voluntary payment provision based on the mere idea that the insurance company denied, especially where here the contract gives the insurance company discretion to deny. It was allowed to deny this claim under the contract. Your Honor, I see my time has expired, and I thank you, unless you have any further questions.
Thank you very much, Mr. Stevenson. Thank you again, Mr. Connolly. We appreciate your excellent arguments. I neglected to introduce Senior Judge Lorenzo Marquez at the outset. I'll do so now. We were pleased that he has been able to join us for this case. But the court is now going to take a brief recess so we can constitute a revision and, so we can reconstitute our division. And the bailiff may announce the recess, and we will be back shortly to hear the oral arguments in People v. Cano. argument in People v. Cano.
Good morning, and may it please the court, Gregory Lansky from Mr. Raymond Cano. An adverse effect resulting from the conflict of interest concerning Sergio Aguilar was demonstrated here. It was in this case that where the Colorado Supreme Court adopted the Fourth Circuit Court of Appeals tripartite adverse effect test set forth by Judge King in United States v. Nicholson. And that tripartite adverse test consists of 3 prongs. The first prong is identifying alternative strategy or tactic that counsel could have pursued, showing that that strategy or tactic was objectively reasonable under the facts known to counsel at the time of the strategic decision, and to establish the failure to pursue that tactic or strategy was linked to the conflict. The last prong, the third prong, can be proved in 2 different ways. One of them, which is pertinent here, is with regards to showing that the strategy or tactic was contradictory or inconsistent with counsel's other loyalties or duties. So this case was remanded from the Colorado Supreme Court, and in the district court, 7 different proffered strategies were proffered to the district court. The third prong, the prosecution, the state conceded the first 6 strategies concerning the third prong. The district court expressly found the third prong was met for all the proffered strategies. So for the purpose of today, and because we have a short time, I want to focus on the other 2 prongs, the plausible prong and the objectively reasonable prong. And particularly I want to focus on the objectively reasonably prong, and I want to emphasize 3 things about that prong. One, regards to the standard review. This prong is a conclusion of law, so this court reviews this prong as a de novo standard of review. 2, the reason why Justice Hood adopted this second prong, it was done for the benefit of defendants. It was without this prong, an adverse effect would be too difficult to prove. This prong does not allow the district court to consider the subjective interpretations of counsel why he or she pursued or did not pursue a specific strategy. And with regards to the third point I want to make with regards to the objective reasonable prong is how the other courts have interpreted this prong. And you look at the 11th Circuit Court of Appeals, Freud v. Butterworth, they say all defendant needs to do to prove the second prong is to show that the strategy had a sufficient substance to be a viable alternative. Justice Harris in Villanova, a decision by another division of this court, indicated that the strategy or tactic has to be not detrimental to the defense. So it's the second prong, what I want to emphasize, the second prong was really done for the benefit of the defendant. It's not a high threshold. And with that understanding of the 3 prongs, I want to now go to the proffered alternate strategies and tactics that were provided to in the district court. And the one that I want to begin with is the sixth one. That concerns Sergio Aguilar being an alternate suspect. And to understand why this is a viable strategy, you have to understand the facts of this case. And the facts were as follows. This is a homicide case. The victim here was a member of a gang. The victim wanted to leave the gang. He was specifically threatened by 2 gang members. Eduardo Garcia, his name is Grizzly, and Marco Limos, his name is Shadow. They told Crow, the victim here, said, if you want to leave the gang, there's only one way out. It's by a casket. We're going to kill you. That's how you get out of it. That's how you get out of this gang. So he said, you do whatever you want to do. Months passed. There was no contact between the victim and the other gang members. I want to point out Sergio Aguilar was a member of this gang. On New Year's Eve, Shadow, the one who threatened the victim here, set up a New Year's Eve party. And him and Grizzly, Eduardo Garcia, and Demon, Arthur Hurtado, called up the victim after months of no contact, encouraged him to come to the party. So at that point, the victim decides to go to the party with his girlfriend, Jennifer Arrieta. He gets to the party, what happens? He's greeted by Demon, one of the people who's encouraged him to come to the party. They tell him where to park, away from the house. They tell him to go to the front, and they meet Grizzly, another person who threatened him and who also encouraged him to come to the party. Demon then takes them downstairs where they meet Shadow, the other person who threatened them and encouraged them to come to the party. A picture is taken downstairs in the basement of this party. The victim and his girlfriend walk up the stairs. They are greeted by Arthur Hurtado, Demon, the person who threatened them, who told them where to go to the party. He stops them on the stairs. He gets his cigarette lit. Moments after, the victim is stabbed. The victim is now in the kitchen. And who's in the kitchen with the victim? Sergio Aguilar, Shadow, Demon, and Grizzly. The three central players who threatened him and told him where to go and encouraged him to come to the party, now with Sergio Aguilar. Where did they take the victim's body? They dragged the victim's body to Sergio Aguilar's car. Where was Sergio Aguilar's car? It was parked right up front. Jennifer Arrieta wants to go in a car with her boyfriend. They say, no, you can't come in the car. So at that point, Demon and Shadow run away with another person, Smokey, Eddie Aragon, and then Grizzly and Sergio Aguilar get in the car with the body and with the girlfriend. They drive and they meet up with law enforcement. Law enforcement interviews Sergio Aguilar and the girlfriend. First, they interview Sergio Aguilar. What did Sergio Aguilar say in response? I was on the stairs when the stabbing occurred. The victim fell on me. I saw blood and I carried him to my car. That's what he said to the police officer.
Mr. Lancey, didn't the trial court say that that Aguilar, it seemed odd that Aguilar would be taking the victim in his car to the hospital if he in fact were the killer?
Right, well, there's two responses to that. Number one, Jennifer, the girlfriend, wanted to go in a car with him. And if he was so benign and helpful, he would have allowed her to come in a car. But they said, no, you can't come in a car. Secondly, trial counsel indicated that she's seen in her experience people trying to cover up their actions by doing benign after the event things. And the other issue is that question goes to the subjective interpretation, right, of what counsel did or did not do, and that's what Weston Cannon says you can't do. This is an objectively reasonable standard. So for those three reasons, I would say that really has no effect, on with regards to this alternate strategy. But what's very important, when they met up with the police, the girlfriend, who was not allowed to go in the car in the first place, they asked her, who did this? What did you see? What happened? Describe the perpetrator. What did she do? She pointed to Sergio Aguilar. He had the same hair as him. He dressed like him. And then they provided a description which matched Sergio Aguilar as the perpetrator here. And then afterwards, she spends time with Sergio Aguilar, then she starts changing her story. And then after all this happened, what happens? Sergio Aguilar, months later, or a short time later, gets in a drive-by shooting due to gang disrespect and is charged with attempted murder, which is the source of this conflict. So you have Sergio Aguilar, the one who was right there, who says he was right there when the stabbing occurred, removed the body with the people who set up the party, who threatened the individual, and who told the individual where to go. And the girlfriend pointed to him right there. The facts known to counsel at the time shows that he was an alternative suspect. And it's just not me. It's the Colorado Supreme Court. They said that in their decision. Evidence indicated he could be an alternative suspect. And
That's not the same as saying he is an alternate
So
suspect.
he said evidence indicated, that's correct. And then the Supreme Court then said afterwards, but this theory was not pursued.
But you're not suggesting that's binding precedent on us, that he...
I think it's very persuasive. I mean, that's the reason why there was a conflict here, was because of that alternate suspect. That was the basis for the court to say there was a potential conflict, was due to Aguilar being an alternate suspect. Was not for any other proper reason, was for that reason. So in my position, that's extremely persuasive. But not only that, I had two expert witnesses testify here. They had collectively over 50 years of experience. They said he was an excellent alternate suspect. I mean, he was right there. He was changing his story. The girlfriend pointed to him. So you have two expert witnesses who said he was a great alternate suspect. No specific evidence as to that issue. And also during the evidentiary hearing back in September 2010, the trial counsel said it could have been argued, that he was an alternate suspect. So you have the Supreme Court saying that in their opinion. You have two expert witnesses who agree that he could be an alternate suspect. And you have trial counsel said it could have been done, and it wasn't done. So I believe we met our burden of proof with regards to the first and second prong as to Aguilar being an alternate suspect. In addition, they also could have argued, because the theory of this case was this was a setup, a gang setup, and it was an organized hit with my client being the fall guy. They could also use Sergio Aguilar's role and what he did to heighten that argument, to say specifically what Aguilar said, he was part of this gang, he was part of this conspiracy, he had relationships with these individuals, and they could have used them during closing argument to sort of support and amplify the defense theory ran at trial. And this, as Aguilar, as being an alternate suspect, was complementary, to the defense theory because he was a part of that gang. Which now leads me to the fifth alternate strategy with regards to the gang book. When Sergio Aguilar was stopped and the body was in his car, they found a gang book in his car. In that book had the gang subset Elmer Street Locos and had the names of Shadow, Demon, of the people who set up the party, who threatened an individual and encouraged him to go.
Was there any question that the people at this party were gang members?
Well, the purpose of this book was to show this was a gang subset and that they had a prior relationship with each other. And these were the instrumental players in this gang hit. And this gang subset showed they had prior relationships. And it was not only just Demon and Shadow.
Couldn't the jury have concluded that by the fact that they belonged to the same gang?
No, because there was a comprehensive gang, the Serenas, which everybody from California, and then there's an individual gang called the Elmer Street Locos. Counsel testified.
There was no testimony about that at
Nope,
trial?
there wasn't. And that's why counsel wanted to introduce this book during evidence. And what happened when she tried to introduce this book? What did the judge say? The trial judge said, Judge Popovich. He says, you don't have the proper foundation. If Sergio Aguilar is endorsed, then you can try to get it in through that way. Okay? She wanted to get this book in. And the judge says, you can call this witness. And she didn't call the witness. And this was so supportive to the defense theory. And that's why this met the first prong, the second prong, and the third prong. We met our burden of proof in this case. So with these two strategies, I want to reserve for 3 minutes, so I'll leave it here. Thank you very much.
Thank you, Mr.
Yes.
Lansky.
May it please the court, I'm Christine Brady, registration number 24779. I want to first address something that came out in the opening brief and the reply that somehow the trial judge here didn't apply the right standard or didn't understand the standard. This judge did understand the standard and applied it correctly. Besides reciting the correct standard in detail, there was discussions on the record about the standard, and the judge even corrected defense counsel during an argument about the standard and corrected him about even the facts in the record. So the judge is well aware of the correct standard and all the facts in the record. When the judge used the term "no effect on the trial" as its conclusion in some of these prongs, he was talking about adverse effect. This is a judge that's been around a long time. Adverse effect has been the standard for a long time, and that is the correct standard. It's adverse effect on the conduct of the trial. So I'd ask the court to affirm the trial court's findings and conclusions based on the fact that the court did apply the right standard and we do give deference to its findings. Now, on the third prong of the test, the court found that defense counsel never knew about the conflict until after the trial. That was a finding. And so on prong 3, any decisions that counsel made were not tied to the conflict. So the court basically evaluated each of the defense proffers based on objective reasonableness, which is simply stated as, if you call a witness, will he be helpful and no big risk of being detrimental? So on these first 4 proffers, proffer 1, I didn't see him at the party. Proffer 2, I didn't pick him out of the lineup. Proffer 3, the first report to police was he was on the stairs and the stabber was unknown to him. And then the 4th proffer, I didn't see the defendant in the kitchen. Okay, so under the rubric of objective reasonableness, what defense counsel testified to at the hearing was, at best, he was going to get up there and lie. At worst, he was going to do something completely wild card. She used the term wild card, and I believe that the trial court later on interpreted that as, this is a witness that's a loose cannon. We don't know what he's going to say. So she didn't want to take the risk, and that's why she didn't call him. Based on the fact that she didn't know about the conflict, but she did know about the drive-by shooting and that he had been charged with attempted murder for that. And based on that, she was concerned that, this is a quote, he would do anything to save his own skin. It's another reason why she didn't want to call him. She also observed that his girlfriend originally said she didn't see the stabber, but then she ended up changing her mind and coming to trial and identifying the defendant as the stabber. So she was also concerned that Mr. Aguilar would also change his mind and decide that he had seen the stabber and that the defendant was the stabber.
Ms. Brady, how does that square with what Mr. Lansky just told us, that the girlfriend originally said that someone that looked like Mr. Aguilar was in fact the killer?
Yeah, the victim's girlfriend did originally say, I saw the stabber, I looked at him for 40 minutes, I know-
40 seconds, you mean?
I'm sorry, yes, 40 seconds, and I know who he is, and they wanted her to describe the haircut, the clothes. She did point to Mr. Aguilar because he was standing right there. He's a member of the same gang, he's got the same hair, he has the same clothes. She was not pointing to him to say, he's the stabber. Frankly, that would be ridiculous because all of the uncontested testimony is that we had the victim at the top of the stairs, we had the victim's girlfriend behind him, and then, whatever you believe, there was two different versions for Mr. Aguilar. One version was he was behind the girlfriend on the stairs. The other version is, no, I was down in the basement. I didn't know anybody was stabbed until I got upstairs. And then initially, when the police officers were interviewing her about who was the stabber, she said, well, we have to go back to the house and, see if he's somewhere around there. She wasn't pointing to Mr. Aguilar and saying that he was the stabber.
Counsel, do you agree with your opponent that we don't need to get into the third issue, whether counsel did not pursue any of the 7 alternatives or each of the 7 alternatives because of the conflict of interest, or is that also an inquiry that we need to undertake?
What the trial court found was that there's 2 parts to the third prong, and the court found that the part of that prong that says we need to look at each proffer and decide if it was the conflict that caused this decision not to call the witness. That one, the court said, we don't have to look at that because as a finding, it's clearly erroneous standard, is that counsel did not know about the conflict until after. But what the trial court did say was prong 3 is met because of the first part, and that's because even though counsel didn't know about the conflict, we impute it because there's multiple representation of both the witness and the defendant.
But Ms. Brady, if the trial counsel didn't know that Mr. Aguilar was being represented by someone else in her office until after the trial, how could any of her trial actions actually have been affected by the joint representation?
None of them could, but apparently the standard is if there's multiple representation, we impute that there's a conflict, and we look at were her actions objectively reasonable. That's the test.
Do you look at causation at all, of whether the conflict might have caused the actions?
No.
No.
There's no causation at all here. In regard to the 5th proffer about the gang book, the court found that this gang book wasn't really relevant. It made a finding under Colorado Rule of Evidence 401 saying that it didn't really prove anything. It didn't prove who was the stabber. Sure, if they called the defendant to lay the foundation, they could have gotten the gang book in, but it wasn't relevant to prove that there was a different stabber other than the defendant. All it would show is gang relationships. There was already that testimony. And, you know, maybe the trial court found maybe at best it would show there was some kind of conspiracy to murder the victim, but it wouldn't tell you who the stabber was. And then lastly, in regard to the alternate suspect proffer, first of all, if you're going to offer someone as an alternate suspect, that has to be endorsed before trial. Before trial, nobody knew that this witness was going to be involved in a drive-by shooting. So he wasn't endorsed before trial, and that was before any conflict actually existed. But in this regard, the trial court found that under Colorado Rule of Evidence 401 and 403, this particular witness didn't meet the criteria for alternate suspect. And the test at that time was that in order to endorse him as an alternate suspect, the defense would have had to show a direct connection. And certainly there wasn't any direct connection here. And then the court went on and evaluated the alternate suspect evidence under the later standard, which is our standard that we have now, which is a non-speculative connection, and the court found that it failed under that one as well. So if there are no further questions?
I have a further question. What is your response to Mr. Lansky's arguments about the alternate suspect proffer, that there were all these links between Mr. Aguilar and the circumstances that suggested that he, in fact, could have been or should have been an alternate suspect?
Well, what the trial court found was that it would just be a very rare and unique thing for the person who is helping the person who was stabbed, actually put him in his car, taking him to the hospital. He drove him to the hospital and actually stopped when he saw the emergency vehicles and the ambulance to get him some help. Also, the court also found it was logically impossible for this witness to be the killer, because even if you put him on the stairs, which was one thing that he said at one point, he's behind the girlfriend. So we have the girlfriend, who is an unbiased witness, has every reason, first of all, to identify the correct person who stabbed her boyfriend, but the evidence showed, the coroner's testimony and the expert testimony showed that the victim was stabbed downward and from the front, and that it was just logically impossible for someone who was further down on the stairs with the girlfriend in between to have stabbed the victim. Thank you.
Thank you, Ms. Brady.
I just want to pick up where my colleague, Ms. Brady, just left off with regards to location of the stabbing. What she just stated was based upon the prosecution witnesses' testimony, the gang witnesses. It was Shadow's testimony. It was Eddie Aragon's testimony. It was Jennifer Arrieta's testimony. It was Dina's testimony. And if you look at their testimony, it's wildly divergent of where they were, where the stabbing occurred, where Jennifer Arrieta was, how was the victim facing. So to say it was not possible for him to do the stabbing is based upon testimony of all who the defense was arguing were complicit with his gang hit. Yes.
Mr. Lansky, even assuming what you said is correct, what evidence was there that Aguilar was in a position to have been the stabber?
Well, he told his first statement, right after the stabbing occurred, that he was there on the stairs, the victim fell on him, and then he carried the victim to the car. He put himself right there. And again, the other testimony from the other gang witnesses who had, who were part and parcel of this gang hit, said they were all in different places. If you look at that testimony, they contradicted each other. They contradicted how he was stabbed, where he was stabbed, where was Jennifer Arrieta. Everything was contradicted, yes.
Am I correct in remembering that Mr. Aguilar testified that he was above the victim on the stairs?
No, that's not accurate. I don't think he ever said that.
Oh, okay.
I don't think all he indicated at the motions hearing that he was downstairs, or he was downstairs, he went to the kitchen after the stabbing. So he definitely was in a position, to be an alternate suspect here. With regards to, him allegedly, with regards to him, maybe there's a risk of him coming onto the stand, there was no investigation done to Aguilar. The conflict here corrupted every single facet regarding Aguilar. They didn't investigate him, they didn't try to contact the attorney, they didn't do anything. And that's why this conflict was so detrimental to my client's right to a fair trial. So in conclusion, what I'm asking this court is to effectuate my client's Sixth Amendment constitutional right to the right to counsel and to reverse the district court's order. Thank you very much.
Thank you, Mr. Lansky. Thank you again, Ms. Brady. We very much appreciate your arguments this morning. The case will stand submitted, and a written opinion will issue it in due course. We have one case scheduled at 10 o'clock, which is Bloom versus the City of Colorado Springs. Our counsel here for that case? Yes, Your Honor. Yes, Your Honor. Okay, after counsel for the Cano case have removed their papers, then you can set up and we'll hear argument in that case. Let me just briefly review our procedures before we get started. As you know, you have 15 minutes for each side for the oral arguments. We have our traditional timer that's green when you start, amber when you have 5 minutes, and red when your time is up. There's also a digital timer that you can use to gauge how much time you have, and if you're representing the appellant, how much time you would like to reserve for rebuttal argument. We have read the briefs and we've had a chance to look into the record, so if you may wish to focus your argument on the legal issues rather than the facts, but of course how you present your argument is up to you. You should know we have a toggle switch on the podium that you can raise or lower to suit your convenience. We are also live streaming the oral argument, so if you have any confidential information, you should be careful as how to refer to it. And finally, I would ask that if you have a cell phone to make sure that it's turned off so it doesn't interrupt us during the oral argument. And with that having been said, we're ready to hear the arguments in this case.
May it please the court, my name's Ryan Doherty, registration number 44612, and I'm here on behalf of the City of Colorado Springs. I'd like to reserve 3 minutes for rebuttal.
Sure.
The city requests that the trial court's judgment be reversed in this case for 2 overarching reasons, which will incorporate Finney's five factors. The first reason is that statutory words matter. We assume that the legislature has said what it has intended, and the courts are supposed to interpret and enforce the statute pursuant to its plain meaning. In this case, statutory words inform both the intent and purposes of the statute. They were ignored in this case. And that is the first reason that the trial court's ruling should be reversed. The second overarching reason that the trial court's judgment should be reversed is that substantial compliance matters. This is a standard. It is not absolute, but it does require significant conformity. In this case, in order to prove that she had complied with the CGIA, Bloom, having not addressed the intent and purposes of the statute, was then required to provide some evidence, as Finney suggests, of agency, equity, or misrepresentations by the city. And in this case, the record is empty regarding all three of those factors. That is the second reason that the trial court's, overarching reason that the trial court's judgment should be reversed. I want to jump back to those important statutory words where we all start our, or begin with our understandings of the case. We were supposed to look at the statute itself. The statute itself, as it pertains to this case, requires that a claimant provide notice to a governing body or the attorney that represents that body. In this case, there's no evidence that any of that happened.
So, Mr. Doherty, how does what you're saying square with the Supreme Court's decision in the Finney case saying that a substantial compliance rather than a strict compliance test should apply?
I don't think it conflicts. What I would say is Finney has directed us to look at the intent and purposes of the statute. The Finney court could not have changed what the legislature said, which is these are the two individuals that are supposed to receive a Section 109 notice of claim. However, what Finney says is if you can't comply with that, we understand, and Brock even mentioned that agency could be a possibility. Also equity, and also misrepresentations by the court.
Why wouldn't equity apply here?
Equity would apply in terms of the city. I do not believe it complies or applies to Ms. Bloom. And
Please explain.
here, sure. Substantial compliance, as Brock indicates, requires an intent or a colorable effort to comply with that statute. So in this case, Bloom, and it's not Bloom, she was not pro se, it was a veteran attorney, never intended to serve the two people that are explicitly pointed out in the statute.
What leads you to that conclusion?
His testimony itself. If you look at his testimony, he says that he looked to maybe a website.
Who's he? I'm sorry.
Mr. Waters, which was Mrs. Bloom's attorney, a 37-year practicing attorney. He looked at a website to determine the address of the Department of Risk Management. That's the sum total of the testimony regarding that.
And he received an acknowledgement from Risk Management on Colorado Springs letterhead, City of Colorado Springs letterhead, indicating, okay, we've received your claim, we've got these two claim numbers. Why wouldn't that give rise to a reasonable inference that, I've given the proper notice? I've told them so that they can come out and investigate, and that's exactly what they did. I mean, is your client in some way claiming that it was precluded or hampered in its ability to investigate the claim and to, assess its risk? Isn't that what risk management does?
Yes, I do believe that we were hampered, and I think patently so. The purpose of the statute is that the governing body, or the city attorney in this case, would be directly involved, advised, and notified of potential litigation. That could not have happened in this case because there is no evidence that either of those bodies received notice in this case. So, without notice, the governing body or the city attorney couldn't have effectuated any of the purposes that have been identified for the statute. Those are to correct a dangerous situation, to investigate potential litigation, settle a claim before litigation ensues, or to prepare lawsuit defenses. It's important to recognize that the legislature chose these two bodies because they control the pocketbook and they control the prosecution and defense on behalf of the governing body. So in order so that they can effectuate those specialized purposes, those specialized duties of their offices, they would have to receive notice to prepare those defenses, to put aside sufficient financial resources, or correct a dangerous situation. In this case, you couldn't rely on DRM to do that, not only because the evidence is empty regarding what their duties and responsibilities are, but also because they don't have the capability to do any of those things.
And how does a citizen know that? I mean, risk management suggests that it's somebody acting on behalf of the city to mitigate danger to the community, or, you know, a dangerous condition, dangerous situation.
First, I want to distinguish that fact because, again, Ms. Bloom was not pro se in this case. She had an attorney that had been practicing 37 years that chose to send a letter to DRM.
And DRM sent a response.
They did send a response as part of their duties. However, in order for that to have any effect, you would have had to demonstrate, and not you, excuse me, but Ms. Bloom would have had to demonstrate that there was some agency that would have allowed DRM to accept that notice of claim on behalf of the people who should have gotten it. And that record bears no evidence regarding that fact.
Couldn't it be inferred? Why not? That risk management communicates with the city attorney's office and would tell them about this?
I would say in this case, no, it cannot be inferred. Because what Finney has told us is that if you can't get there, if you can't do it the right way by reading plain English, you have some other options. And one of those is agency. It's not inference, it's agency. Because the CGIA is important. In enacting the CGIA, we breathed new life into sovereign immunity. We offered waivers to that immunity, but we also required claimants who wanted to invoke those waivers to follow certain conditions. And in fact, Section 102, which bears the policy of the CGIA itself, says that governmental entities should only be liable to an extent and subject to such conditions as are provided by this article.
So by assigning a claim number, the risk management department seemed to be giving an indication that there was a claim filed. Shouldn't the court give any effect to that?
Risk management does deal with claims, I think the evidence shows. What they do not deal with is notice of claims. Notice of claims are a term of art. They suggest that litigation is ensuing.
Well, the only way you can make a claim against the city of Colorado Springs is if through a waiver by the CGIA, if it's this type of a claim, right?
I believe the answer is yes, through a waiver, but you also need to comply with the statute itself.
So, Mr. Doherty, you said that one of the criteria set forth by the Supreme Court was agency. So if the Risk Management Division was sending a letter on Colorado Springs letterhead, why wouldn't that constitute apparent authority on the part of the division, the Risk Management Division, as Judge Schwartz found?
And I think this is a problem that not only the trial court found itself, but also the briefing from Ms. Bloom. That could not be the case Because apparent authority springs from acts of the principal, not acts of the agent. And in this case, the agent would have to be the Department of Risk Management. So apparent authority bases itself on the conduct of the principal. And if you look at Lucero, which is from this division, they specifically identify the principal in that case who was vested with charging authority. And in order that a delegation occur, they must allow agency to occur. They must take some action to demonstrate that a third party, in that case, a police officer, was delegated authority. In this case, that did not happen. What you had here was an absence of evidence regarding that. The record does not bear that out because, and actually the court does say that the city made no misrepresentations regarding compliance with the CGIA.
Excuse me, Mr. Daugherty, you wanted to reserve 3 minutes for rebuttal. You have 2 minutes and 40 seconds now.
I do. I would like to reserve that if I may, Your Honor. Thank you very
Sure.
much.
Thank you.
Good morning. May it please the court, my name is Lucas Lorenz. I represent the appellee and plaintiff, Eugenia Bloom. The purpose of the CGIA notice requirement is to help governmental entities, manage claims. That's exactly what happened here. Another important purpose of the CGIA notice requirement is to avoid having these notice provisions act as a trap for the unwary. And the trial court's order specifically avoids that. These are straight out of Finney. Finney is the law of the land for our purposes with regard to the CGIA notice requirements. And the trial court's order is entirely consistent with Finney and with the record in this case.
Mr. Lorenz, you said that the courts have said that the CGIA should not be a trap for the unwary, but as Mr. Daugherty said, Ms. Bloom was represented by an experienced attorney, and if he had looked at the statute, he would have seen whom should have been served.
And I'm glad you brought that up, Your Honor, because the statute says that as it applies to this case, it has to go to the governing entity or the attorney. That's the extent of the instruction from the statute. So what is someone to do in a situation like this? Okay, for the city of Colorado Springs, who do I actually need to bring this to? Well, you need to look no further than Exhibit 2 to the response to the motion to dismiss. In the record, the Colorado Springs website, it's entitled, and I apologize, I'm paraphrasing here from memory, but it's entitled, How to File a Claim Against Colorado Springs. This is the instruction that comes from the city. Hey, you have a claim you need to bring against the city of Colorado Springs. Here's how you do it. You look at the language on that website. What kind of words are used? In the very first paragraph, if you have a claim about property damage liability, motor vehicle liability, personal injury liability, and again, I'm paraphrasing, but
So is your contention that the steps that were outlined on the website were the ones that were followed by counsel?
Counsel did not, well, let me back this up. The website says, at the very beginning, it says you have to submit your claim to the Department of Risk Management. Department of Risk Management is who handles the claims against the city. Now, counsel for Ms. Bloom did submit the claim to Risk Management. He didn't fill in the form on the website, to my knowledge, but the claim went to Risk Management. Risk Management acknowledged it. There's no dispute here that the claim did go to Risk Management. The question is just, was that sufficient?
Now, your learned opponent pointed out that in order for there to be apparent authority, you have to have some communication by the principal indicating that the delegee has authority to act for the principal. Is it your contention that this statement on the website complies with that? Gives the indication from the principal that this is how you do it?
Absolutely. That, in addition to the fact that the letter, the acknowledgement letter that came from the Department of Risk Management that's on City of Colorado Springs letterhead, I mean, we have to assume that the Department of Risk Management isn't just some rogue agency purporting to be acting on behalf of Colorado Springs. And we have to assume that there's a reason it's on that letterhead. But certainly directly to the point, that website does say that, because the website says in so many words, look, if you have a claim against the City of Colorado Springs, not just the Department of Risk Management, not just the Utilities Department, you have a claim against the City of Colorado Springs, it's got to go to Risk Management. They're going to handle it. They're going to investigate it. So I think that that does resolve the apparent authority issue. But we don't even necessarily need to get to apparent authority, because I think by virtue of the fact that Department of Risk Management is an agency of the city, there's actual authority there. So we don't need to necessarily even go into alternative theories of agency. Now, when we look at the considerations that were laid out by the Finney Court, and we break those down, to preface this, it's important to note that there's nothing in Finney that says you have to have each one of these considerations present as if it's a bullet-pointed checklist. But these are the things that we're going to take into account. And that includes agency, as we discussed. There's also equitable considerations. And that goes back to not being a trap for the unwary. And in this case, you know, it's interesting because the city argues that they didn't have, they were hampered in assessing the claim here. What the record shows, and this is undisputed, is that on the very day that this incident happened, Ms. Bloom had at her property not only somebody from Department of Risk Management, but also somebody from the Utilities Department. So from day one, the very entity that is responsible for investigating claims on behalf of the city, that the city has put forth as the entity that is gonna handle these claims, whether they're property damage liability, motor vehicle, whatever it is, that's who handles these claims. That entity is on site that very day and continues to be involved. That entity does investigate the claim. Ms. Meyer, the representative of the entity that testified at the Trinity hearing, she testified. Yeah, she handled it. She investigated it. They assigned claim numbers. They corresponded with Mr. Waters. They asked for more documentation. He submitted documentation about damages. So I don't know that the record supports an argument that the city was hampered in assessing the claim. If anything, the record shows that the city had every opportunity to assess the claim.
Counsel, how do you respond to your opponent's contention that, you know, there was no misrepresentation by the city? So, you know, what do we make of that? Is that true? Is it not? What do we take from there?
So, and I'll use as an example what happened in Finney, where somebody told the claimant, yeah,
Yes.
you've submitted your claim, you're fine. Basically something like that. Nothing like that happened here. I would agree, there's no evidence of that here. So as to that consideration, was there a misrepresentation like that by the city? No, we don't have any evidence of that, but that's not dispositive. That's not the end of the analysis, because again, we're not dealing with a checklist where each point has to be checked off in order to reach the trial court's conclusion. So we still have to look at all these other factors, and looking at all these other factors, they all weigh in favor of Ms. Bloom. And going back to the investigation, you know, it's notable that even on the day of the incident, Ms. Meyer, and this is in the record, Ms. Meyer gave Ms. Bloom a document that said how a claim should be filed with the Risk Management Department. Ms. Bloom spoke with Ms. Meyer on several times about the claim in the ensuing months. So there's every indication that the city had more than adequate opportunity to investigate the claim, which is, again, that's the very purpose of the notice requirement. And that purpose was achieved here.
Mr. Lorenz, do you think that the city's course of conduct here constituted a misrepresentation about the requirements under the Governmental Immunity Act?
You know, Your Honor, I take misrepresentation as a pretty strong word, and I don't know that I would go that far. Certainly, if we look at the city's website, they're telling people, hey, you got to send your claims to the Risk Management Department. they're kind of leading them down the primrose path in a sense. And then, as in this case, when that happened, trying to pull the rug out from under them. But I don't know, maybe I'm too cautious, but I don't know if I'd go so far as to say misrepresentation, and certainly not in the context of how that word was used by the Finney court. So I don't want to give the impression that I'm saying we have that same sort of misrepresentation here.
But nobody, on behalf of risk management or whatever entity Ms. Bloom was dealing with, they never corrected her in terms of saying, wait, you can't file with us. Would that be fair?
That is absolutely correct. There's this correspondence going back and forth between Mr. Waters and Ms. Meyer of the Risk Management Department. There were conversations between Ms. Bloom and Ms. Meyer, and there's no evidence in the record that anyone, whether it's Ms. Meyer or anyone else from the city, ever said, you know, hey, pump the brakes. If you think you're submitting some kind of CGIA claim, you need to go down the hall or go to the other building or notify whoever it is. That never happened, certainly. And that, again, goes back to the balance of the equities. And, you know, it is a balance. It sounded to me like the city wants to have the equitable considerations only viewed from their perspective, but the court has to look at both. And from the perspective of Ms. Bloom, you know, is this an equitable scenario to say on your website, to tell her through this document she's handed on the day of the incident, that, yeah, you submit your claims through risk management, and then later say that it's not. I'm sorry, Your Honors.
We've all got kind of dry throats today.
So, you know, also another big issue here is obviously the intent and purpose of the statute. Now, when it comes to arguments about the plain meaning of the statute or looking at the statute itself and that words matter, you know, certainly that is the state of the law when it comes to legislative interpretation, but that's not our case. Finney has already resolved that for us. Finney has already told us what the words mean in that statute, and Finney is still good law. And those words do not mean strict compliance, they mean substantial compliance. Looking at Finney and the purposes of the statute, Finney laid out a number of underlying purposes of the statute, including avoiding prejudice, encouraging settlement, providing the entities the opportunity to investigate claims, remedy conditions, and prepare defensive claims. Now here, there's no evidence of prejudice. And even though Ms. Bloom bore the burden of proof in the Trinity hearing, she doesn't bear the burden to show an absence of prejudice. If that were the case, it would be tantamount to saying we're going to have a rebuttable presumption of prejudice, which is not the case. So it was up to the city to put on any evidence that they were prejudiced by this, and there is no evidence of that. What we have is Ms. Meyer saying, I didn't forward the notice of claim to the city attorney. I didn't forward the notice of claim to the city council. That's not enough to say that there's prejudice. It's akin to the situation in an insurance claim, where an insurance company says, oh, we didn't get notice, so we're going to deny the claim. Well, that's not, the analysis doesn't stop there. You have to go the next step. Were you prejudiced? And merely not receiving notice is not the same as being prejudiced by something.
We just had a case about that this morning. There's a new rule from the Colorado Supreme Court you might want to look at. Anyway.
So I might have entirely misstated that.
Forget about that for this purpose.
But,
Sure.
but on that prejudice prong, I mean, to the extent that the city is now claiming we were hampered in not being able to investigate, settle, resolve this out of court. Couldn't that be fixed by granting them a stay, sort of an after-the-fact stay? Give them that time to go figure out what investigation they need to do that's separate and apart or additional to whatever risk management did.
Well, nothing's stopping the city from making a settlement offer, trying to resolve the claims in this action. And, the record doesn't contain evidence about whether or not there have been settlement discussions. So be that as it may, but nothing's hampering the city from saying, oh, even though we got served with your lawsuit, we've looked into this, we contacted Ms. Meyer, who did all this investigation, we reviewed her file, we now see oh, even though we didn't know about it before, oh, okay, yeah, this is a legitimate claim, let's resolve this. That could still happen. And they had every opportunity to do that before the lawsuit was filed because they'd been investigating it since day one. And we're not talking about an investigation by a department, say it was just the utilities department. Maybe that might have been a different story, maybe. But we're talking about the risk management department. They investigate claims. They're going to be, I mean, it's reasonable to assume that they're going to be involved with the city attorney. It can't be alien to them to receive a claim and say, you know, I wish we could get an attorney involved, but I don't know how to do it. That can't be the case. That would be a completely unreasonable inference. And under Finney, Ms. Bloom is the one who's granted the reasonable inferences of the evidence in this context. So if you look at another aspect of Finney, another purpose of the statute was, you know, give them an opportunity to remedy the conditions. Well, unquestionably that happened here. They were on site from day one. Ms. Bloom was corresponding with Ms. Meyer. After that didn't solve things, Mr. Waters was corresponding with Ms. Meyer, providing her documentation. All of that was happening. And the city had every opportunity to do something about this, to perform a full investigation. So at the end of the day, when you look at this, you look at the facts in the record, you look at the considerations that Finney has laid down for us, and you take that together, you see that the trial court's order was absolutely correct, and we would respectfully ask that you affirm.
Thank you,
Thank
Mr. Lorenz. Mr. Doherty, you have just a little over 2.5 minutes.
Thank you, Your Honor. I wanted to go through just quickly and address some things that were said. A trap for the unwary, manipulation to avoid a proper suit. There's no evidence of that. The trial courts told us that. So there's no trap here. There was just someone who didn't want to read a statute. With regard to Exhibit 2, we discussed that quite a bit. That was not in evidence. And it wasn't in evidence for a good reason, because Mr. Waters, Ms. Bloom's attorney, didn't rely on it, couldn't identify it, didn't know what it said. So if he did not rely on it, didn't even know it existed, then we can't use it in this case to bootstrap an unsuccessful argument. And thirdly, along with that, if you did look at the website, it's emblazoned with a huge reminder that says, by the way, you have to comply with 109 to preserve your claims against the city.
Regardless of whether Mr. Waters examined it, why couldn't Ms. Bloom rely upon it? Why shouldn't she be expected to rely on it?
She could have, but she did not. There's no evidence that said that. And secondly, I think that important advisory notice that is, again, in plain English, says notices of claim are different. They're terms of art. You need to comply with the statute. Would suffice to say Mrs. Bloom should have known, if that were the case.
Mr. Doherty, is there any evidence in the record of any communications between the Division of Risk Management and the City Attorney's Office?
No. In fact, there is none.
Is it nevertheless reasonable to assume that the Division of Risk Management would communicate with the City Attorney's Office, given that the whole purpose of the Governmental Immunity Act is to insulate municipalities and other state entities from liability in a wide variety of circumstances?
And I think the answer to that is no, because you could not do that unless there was evidence to support that. And there isn't. And there couldn't be, for that matter, if we got there. I did want to mention, before my time runs out, if we look at risk management, there's been a lot of talk as why can't we assume or impute some knowledge to the governmental entity. I just asked you to look at cases before you. If you look at Armstead, Brock, Finney, Christensen, or Mesa County, they all deal with risk management. Not one of those cases holds that notice to risk management is sufficient to comply with the CGIA.
You do realize that Finney effectively overruled Brock?
I realize that Finney overruled Brock to the extent it suggested that the compliance standard was anything but substantial. But if you look at Brock, it has been cited since Finney for various propositions for good reason, because it has been only overruled to that extent. If you look at Brock itself, it says that actually in this case, in Brock, there were 5 letters that went to risk management. They paid medical expenses and PIP benefits. And that court said, even applying the substantial compliance standard here, there's no intent and no colorable effort to comply with the statute. That is the same thing that applies in this case, and that is why we ask that you reverse the trial court's judgment and dismiss this case with prejudice. Thank you very much.
Thank you, Mr. Doherty. Thank you, Mr. Lorenz. We, again, appreciate both of your arguments this morning. A written opinion will issue in due course. That concludes the oral arguments for Division 1 this morning. The court will be in recess, and the bailiff may so announce.